Raise your right hands. Do you solemnly swear and or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. And so what's going to happen next, ladies, I'm going to give you, Miss Chen, the opportunity to speak first. You know, it's up to you to provide proof to me that the defendant, Ms. Brown, did default in the terms of her lease by not paying rent. It's also up to you to provide proof to me that you comply with all the laws of this state as they pertain to evictions. Now, while Ms. Chen is speaking, I'm going to ask that you, Ms. Brown, refrain from interrupting her. I need to make sure I hear everything that Ms. Chen is stating. Okay, Ms. Brown?
Yes, sir.
And afterwards, once Ms. Chen is through, I'm going to give you, Ms. Brown, the opportunity to defend yourself. It's going to be up to you to provide proof to me that you should not be evicted.
This opening sets the tone immediately. The judge lays down strict courtroom rules, explaining who carries the burden of proof and how the hearing will unfold. There's no drama yet, but the tension is structural. You can feel how everything hinges on documents, payments, and legal compliance rather than emotion. When the landlord begins outlining the lease terms and missed rent, the case quietly tilts toward enforcement. It's a reminder that in court, calm instructions and paperwork often decide the fate long before voices are raised.
For whatever legal reasons you can deem so, approve so. And while you're speaking, Ms. Brown, I'm going to ask that you, Ms. Chen, refrain from interrupting her so I can hear everything that Ms. Brown is stating. Okay, Ms. Chen?
Yes, sir.
All right. With that being said, are there any questions before we proceed on with today's case?
No, sir.
Okay, Ms. Chen, you may proceed with your case, ma'am.
Yes, sir. So I have a lease agreement dated July 22nd for a monthly housing installment rate of $659. There is a concession of $220 per month, making the rent owed $439 per month. We do need to amend our petition to ask for November and December's rent, please. But outside of that, we do have an electronic signature on this document going until the end of July 2026, or July 21st, 2026. This was signed by us. The last payment we received for this housing installment was October 3rd. And so we have failed to receive any payments in November and December. And that is why we filed for eviction. We served a 3-day notice to vacate. It was hand delivered on the 8th of December.
Okay. I'm looking through some of the documents you provided to me. I see that you provided me with a copy of the notice to vacate. Looks like Mr. Whittington was the person who actually delivered this. Is that correct?
Yes, sir.
Okay. And I also have, looks like it's a summary. It's a ledger, which details all of the transactions. And this is up until December 7th. And as stated in your testimony, the last time you all received a payment, you said October 3rd, but it does say from October 3rd right here. $195. I see that. The next document I have in front of me.
Here, the judge carefully reviews the notice to vacate, the ledger, and the lease itself. This is where suspense lives for eviction cases. One missing signature or incorrect notice could change everything. Instead, each document checks out. The judge confirms dates, payments, and delivery of notice, closing off potential procedural defenses. The landlord doesn't need theatrics, just consistency. As the judge moves on, you can feel the window for dismissal quietly shut, leaving the tenant with only personal circumstances to lean on.
It is a lease between you and the tenant. It does indicate that it was executed on or around July 22nd, 2025. Everything was done electronically. And it does detail the terms of lease, as you stated on the oath. All right. And anything else before I move on to the defendant?
No, sir, just that we have not received payment as of right now, and we are seeking eviction.
Okay. All right, Ms. Brown, here's your opportunity to defend yourself. Tell me why you feel like you should not be evicted from this unit.
I don't have a problem with being evicted. I'm currently packing and moving out. It is taking a lot longer than I expected because I don't have a vehicle to move stuff, and I don't have anyone helping me. The reason I didn't pay the rent, I didn't get my full Social Security check. I'm on disability, so I only get one check once a month. And I informed them that I didn't get the full payment, and they said that I had to pay the whole thing before it got the eviction notice. And I don't have that amount of money. And I've tried to ask people to help me, but I don't have that much family. And so I'm moving out. I'm not trying to stay here any longer than necessary. I just have a hard time packing because I don't have any transportation. The car that I received from my mother when she passed away, the tags are out and I don't have a driver's license. So,
Ms. Brown, have you been here before?
yes, sir. I was here a couple of weeks ago, maybe like 2 weeks ago, but the situation hasn't changed for me. I don't really have help. My fiance works every day except
Uh,
for weekends.
Correct me if I'm wrong. Ms. Chin, what happened with that case about 2 weeks ago?
I think it's because they didn't give me the eviction notice the right way, so we
Proper
had to.
notice to vacate. Okay.
Yes, sir.
So this time around, they did give you proper notice.
Yes,
Okay.
sir.
All
He
right.
did hand it to me.
Okay. That was the problem last time. So I didn't mean to stop you, but
Oh no, it's okay.
groundhog.
This is where law meets reality. The tenant doesn't deny the debt or the eviction. Instead, she explains disability income, missed payments, lack of transportation, and the slow process of packing her life alone. There's no legal argument, only survival. The judge recognizes the story, even recalling a prior hearing, but acknowledges that hardship isn't a defense under the statute. The tension here isn't about winning or losing. It's about watching someone realize that honesty doesn't always translate into protection.
I heard this your response from the last time, and it again. I heard it. So there's no really defense. It's just that you're just having a hard time getting everything moved out. I heard
Yes,
you telling me about your fiance and about your financial situation. I was just wondering. I said I know I heard this case, before, but now I remember what happened.
Yes, sir.
Okay, all
But
right.
that's the only thing. Like I'm trying to get out as soon as possible. I don't have any funds to pay the rent. I didn't get my full check this month. All the money is going towards working on the RV that we have. But other than that, I'm trying to get out as soon as possible.
Okay. Okay, based upon everything that I've heard today, I'm going to rule in favor for the plaintiff for possession of the property in question, 2826 South University Park Drive, apartment 928, C is in Charlie, Waco, Texas, 76706, as well as back rent in the amount of $878. That's $439 for November, $439 for December, plus court costs, which is an additional $144. You, Ms. Brown, have the right to appeal. Your appeal bond is set at $878. And you have 6 days from today's date to appeal. In the event that you do not appeal on or before that sixth day, and if you are still occupying the premises, then at that time, you, Ms. Chen, may, on behalf of the Grove at Waco, file a writ of possession. A writ of possession is where the constable will serve you with a final notice, giving you 24 hours to move out. If you do not comply with that 24-hour notice, then at that time, they will be back over there within a time frame, with an agreed upon date and time with Ms. Chen. I want to make sure that I'm clear. After you are served with the 24-hour notice to vacate, Ms. Chin and the constable's office will have an agreed upon date and time to meet back over there. They will not notify you of that date and time. It's something that they would agree upon. It could be 6 in the morning, could be 7 in the morning, it could be noon. Don't know the actual date. That is the only piece.
The judge delivers the decision with precision. Possession goes to the landlord, back rent is calculated down to the dollar, and the appeal process is explained step by step. The most chilling part is the description of the writ of possession, a process that can arrive unannounced and remove everything left behind. This segment transforms abstract law into real-world impact. The ruling isn't shouted, it's methodical, and that calm delivery makes the outcome feel even heavier.
People privileged to that information would be Ms. Chin and the constable's office. And so you may get a surprise, and the constable is going to be there, and they're going to make you come out. And then at that time, the maintenance personnel will be able to safely and peacefully remove all of your personal belongings from inside of the unit and place them outside of the unit. And so I just want to make sure you're clear, that I'm clear on this. You do have the right to appeal. But if you do not appeal, and you do not honor the notice given to you after the writ of possession has been filed, then the constable will be back over there to execute it. Do you understand, Ms. Brown?
Yes, sir. So I have 6 days to get everything out.
You have 6 days to appeal, and if you're still staying there after the appeals date has expired, the constable will give you a 24-hour notice to move out.
And is the appeal for paying the back rent, or is just to...
The appeal is disagreeing with my judgment today. That's
Okay.
what the appeal is. Okay. Any questions?
I do have a concern because they told me that my rent that I would owe was close to $2,000. If I had known it was only $800, I would have found a different way to pay it. But they told me...
Let me explain. I do not award late fees. I do not award utilities.
Mhm.
And any other fees that may be charged upon you. That's something that I do not honor in a judgment. The only thing that I can honor is the back rent and court costs. So whatever amount that they are telling you you actually owe them, that is purely between you and them. However, the judgment legally can only be for back rent and court costs and maybe attorney's fees. Okay?
Okay. If I would have known that, I would have had the 800. I had the 800.
Brown, you're not understanding. Okay, let me see if so here's what I'm trying to tell you. In court, the judgment is only for back rent and court costs and maybe legal fees. But the amount you actually owe them is totally different.
Okay.
Okay, so what you actually owe them is more than the judgment amount.
Okay.
All right. So even if you would have taken $878 to them, you would have still been evicted because it's not what you actually owe them. I can only grant them judgment for back rent and court costs, not for late fees, not for utilities or any other fees that you had agreed upon in your lease.
Okay.
All right. Okay. All right. That being said, judgment favor for the plaintiff.
The tenant reacts with shock at the amount, believing she was facing thousands instead of hundreds. The judge explains the difference between what a court can award and what a landlord may still claim privately. It's a crucial legal lesson delivered too late to save the tenancy. Even paying the judgment wouldn't have stopped the eviction. The case ends not with anger, but with clarity. If this breakdown helped you understand how these cases really work, make sure to like the video, subscribe to the channel, and we'll see you in the next video.